which is temporary admission actually applied uniformly across all EU jurisdictions. In practice, although we still see significant differences in interpretation and enforcement. So please, Christine, if you want to start.
Well, the directive is the same for all. However, then there are subjects of interpretation which are done by different member states. The ones where I think you find differences in interpretation are in the residency, that is whether the user or the owner is an EU or a non-EU resident, the use, how is the yacht being used, and what type of evidence each member state normally uses to confirm whether this boat can access temporary admission or not. So in legal, in the law, yes, it's the same for all, but in substance, there is space for interpretation. I don't know if my colleagues would like to comment on that.
I know that I can take the ball. Thank you, Christine, for this introduction and for reminding that the framework is a common European legal framework coming from the European Customs Code. But there are differences between member states, and we know that between Spain, France, and Italy, we know that there are differences in the interpretation of the conditions, in particular about the period of discharge and the events determining the beginning and the end of the period of discharge relevant to consider a yacht lawfully put under temporary admission regime. In particular, the common practice in Italy is that there is a need for the yacht to come from non-European countries and go to non-European countries to end the period of discharge. This is one of the main issues we are currently facing in terms of different interpretations. And I think that it could be a very helpful idea to go through the different interpretations depending on events that can take place in the normal life of the yacht, that is delivery of brand new yachts, sale of yachts, refitting works, major refitting works entailing inward processing relief regime from a customs point of view. I think that in these cases, there are the more interesting differences in the interpretation. I leave to Alex if you want to go deeper into some of these aspects. I can recall that Italy has an official interpretation for considering not necessary for a yacht to reach a non-European destination in terms of non-European port in the case of brand new yachts. And the official interpretation by the Italian Customs Authority is limited to this case. So the yacht can reach the international waters. Customs Authority checks that the yacht reaches the distance of 12 nautical miles from the baselines, and this is considered a successful operation and proof of the exportation for the yard selling a brand new yachts. But official interpretations in Italy stop with this case. So the other cases are usually considered needing that the yacht reaches a non-European port to consider the end of the period of discharge or the beginning of an exportation of the yacht.
Mm-hmm. Thank you. Taking your point, Carla, and related with the question that we presented, certainly the temporary admission regime, it's the proceeds or the source, the origin It's the customs code. It's a unique regulation, which in principle it's applicable as it is in each member state. Does not need an implementation, or as it happens with the VAT directives. Therefore, it seems a little bit surprising that different member states apply the same the regulation in different ways. If I should stress two potential aspects where Spain it's currently applying this regulation, it's slightly different from other member states, I would probably say or mention the difference in terms of the renewal of the 18 months, which in principle are granted for yachts to remain in EU waters. Recently, Spain adopted a more flexible approach whereby yachts could extend these 18 months by the mere fact of crossing in international waters. This was deemed to be a fact whereby the yacht exited the EU customs area and therefore entitled upon return to the Spanish coast, to extend the 18 months. That would be probably one of the aspects that differ from other member states at the moment. The other aspect probably would be related with the possibility of conducting certain commercial operations, as it happens probably in France, Monaco, if I'm correct, as well in Croatia or Greece, which allows yachts to perform commercial activity for a limited number of days in the year under what it's called a Yacht Engaged in Trade program. And that's a situation which at the moment it's currently not possible in Spain. Besides these differences, certainly there are other aspects which are we can probably touch on them in the following questions, but I would highlight these two as the main questions which probably differ with other EU countries. So Jean-Philippe, if you wanna touch from a French perspective.
Yeah, sure. I mean, I'm going back to what Christine said regarding the differences and why we have them. We have two rules, the regulations and the directive. Normally, this should be sufficient for a harmonized application. But those sets of laws do not go into much detail on very basic things, like that ownership plays a role in temporary admission. You need to have non-EU owners. There's no definition of ownership. We've had issues where we have complex ownership mechanisms, like trusts, where we need to know who is the owner for the law. Is it the settlor? Is it the trustee? Is it the beneficiary? And a trust is not really known under EU civil law. So you have that very basic discussion where you cannot even determine how to apply your law. You have the same question regarding the user. We all know that a user needs to be a non-EU resident, but who is the user? Is it the ultimate beneficial owner? Is it the person currently on board the boat? Is it the person that uses the boat most of the year? Is it every single guest on board is a user? Is it the captain of the boat? All these issues are left really to the interpretation of local customs. And I think that's why we have such disharmonized application of the rules. And unfortunately, as you say, I mean, we could be here all day listing every single difference between each country because we have so many of them, even though we all refer back to the same law. And normally we should be harmonized. But I think the very basic root of the problem is that we have insufficient information on the interpretation of the laws by the European Court of Justice and by local authorities. And what we see in our practice is that we don't have much to refer to except our own interpretation and to convince the authorities that we're correct, but we don't have a lot of binding precedents, guidelines, rules on which to refer to in specific cases. And that's where I think, every single difference comes from that original sin of not having a harmonized set of rules which we can apply.
Thank you. I think,
thank
sorry,
you.
Carla.
I was listening to your suggestions and insights about the differences around our own jurisdictions. And I was thinking that all these issues become even worse if we think about the need to set up an appropriate due diligence in terms of customs compliance of a yacht in the case, for example, of a change of ownership. And if you want to check if the yacht, the target yacht in case of second-hand yachts in sales and purchases, has complied with the temporary admission regime during her use with the owner, because according to the different interpretations, you could have behavior which are considered okay and appropriate for one jurisdiction, but might be challenged from another point of view of a different jurisdiction. And we all know that possible breaches could be seen as smuggling in single jurisdictions. And this is not a kind of breach which ends with the sale of the yacht. So our concern has new theaters in terms of setup of the appropriate checklist for a customs due diligence in the case of yachts under temporary admission regime for some months or some years around different jurisdictions, with the potential breach for the single place where the yacht was used. Some cases are really have a very, very low probability to be considered at a later stage as a possible breach, but some other breaches could be seen as a potential source of risk also for potential buyers at a later stage.
It's a good reflection, Carla. Thank you for the insight.